Good morning, everyone, and welcome back to Law Statistics. Today's presentation is based on the topic how to structure plain document. Order 6 Rule 1 of the CPC defines pleadings as a plaint or a written statement. This is one of the starting steps to initiate a civil suit in a court. After employing a counsel, the plaintiff files a document in the court containing the facts and circumstances of the case. There are some general rules of the plaint. Order 6 Rule 2 Clause 1 states that every pleading shall contain only a statement in a concise form of the material facts on which the party pleadings relies for his claim or defense, as the case may be, but not the evidence by which they are not to be proved. General rules of plaint. A plaint is to state the facts of the case and not the legal provisions applicable in the case. A plaint must contain only material facts. Plaint must have relevant facts on which either party relies, but it should not state the evidence by which the fact is proposed to be proved for its validity. A plaint must contain a brief fact which somehow explains the whole case in short. In case of Kedar Lal versus Hari Lal, the apex court held that the parties to a civil suit are obliged only to state the facts and situations that happened and on which they rely in the pleadings, and to apply the law is the duty of judiciary. It means that the party should state what their claims are and why they should be granted to them. We can take an example where Mr. T complained about Mr. P hitting him. Mr. T should explain only what caused the fight, what was Mr. T's role in the fight, why did Mr. P hit him, and should not explain what offense has been committed by Mr. T. The rule can be explained in the case of Union of India versus Sitaram Jaiswal, wherein the apex court held that if there is a point of law which is in dispute or which has become part of the dispute, the point of law must be explained in the pleadings with necessary reference to relevant and vital facts of the case. Further, in the case of Udav Singh versus Madhav Sindhia, the court averred that material facts, all those primary facts that are relied on by the parties either to substantiate their claims or establish their cause of action, are used for their effective defense or counterclaim against the claiming party. As per the rule, evidence must be omitted from the pleadings, or it can be said that the party is not obliged to mention the document of the evidence produced before the court to be used against the party. According to jurisprudence, there are two types of facts: facts probenda and facts probendia. Facts are elaborated by Order 6 Rule 2 mentioned in the pleading. Facta probentia is just different and it's contradictory in nature. That means facts which are in the form of evidence produced in the court. The foremost fact which is in the form of evidence and which shall be used by the parties to validity of the fact probenda, it shall not be mentioned in the pleading. The rule of brevity, that means last and final, basic or fundamental rule, and are not applicable of interpretation, but only one interpretation that the pleader desires to convey to the court. In case of Virendra Kashinath versus Vinayak and Joshi, the court observed that pleading must be brief and niggling should be avoided. However, it does not mean that essential facts need to be omitted or missed in an attempt to achieve brevity. Additional rules for drafting plaint. The rule applies on the plaint and written statement equally. There is a certain sine qua non under Order 7 Rule 2 and 3 applied to the plaint only. Rules keep changing and amending according to the decisions of the court. Major four rules are: plaint out, to state the accurate amount of compensation claimed by the plaintiff from the defendant. The second one is a plaintiff must disclose every detail of the property in dispute to allow authentic identification of the property as well. The next point is When the plaintiff has commenced the proceedings as a legal representative, the plaint must contain particulars to show that the representative has sufficient interest to commence the proceedings. The last one is plaint must contain a concise explanation for the reasons why there was a delay in filing the plaint and why such delay should be condoned. That's all for the presentation. Thank you and have a wonderful day ahead.